This next panel is, again, another wonderful panel, and I very much appreciate they're speaking to us on unfortunately, a broad range of topics, and they are being given a 1 hour limitation. But we have joining us Kaitlin Gurney from Ballard Spahr, who has helped me with some of our Table Talks programs that I mentioned previously, and Professor Kirtley, who is who used to be the executive director of the Reporters Committee for Freedom of the Press in Washington, D.C., and is currently a professor of media ethics and law in Minneapolis at the University of Minnesota. Sorry about that. So I'm going to pass it off to both of you, and I'll be quiet and try to monitor the chat. Thank you very much for joining us. I truly appreciate it.
Absolutely. It's our pleasure, Debbie. Hello to all of you. Jane and I are very excited today, after this full day of learning for you, to talk to you about the First Amendment and the many ways that the First Amendment protects you as a journalist, and notably the ways it doesn't protect you as a journalist as well. Jane, as Debbie indicated, has a wonderful background. She's a professor of media law and ethics at the University of Minnesota. And before that, for 14 years, she led the Reporters Committee for Freedom of the Press, which, if you all have not visited their website, it's a terrific resource. Its mission is to protect journalists. It provides information about every state's laws and how they affect journalists, both in news gathering and in any actions against journalists. So commend that to you to take a look at that. And that is Jane's wonderful background. In addition, she's been both a practicing lawyer and a practicing journalist, which is something that she and I share. I'm a First Amendment lawyer in the media and entertainment practice group at Ballard Spahr, where it is our privilege to defend journalists every day and to fight for the materials that they need to gain access either to courts or public records. And like Jane, I was a practicing reporter at the Philadelphia Inquirer and also in North Carolina. So without further ado, we will move on to our program today. And again, Jane will kick us off, but just talking so you understand where we'll be heading today, we're going to start first with news gathering and the ways that First Amendment does, or more notably, does not affect you as a journalist, because you as a journalist are subject to laws of general applicability. And as a media law mentor of mine used to say, you're not special. We would all like to think that we are, but you're a member of the public. You have and you protect the public's right of access as a journalist. Then, second part of our program today, we will focus on the way the First Amendment protects your sources, and also the way it protects your notes, the fruits of your reporting, and the ways that it, once again, does not, or the ways it's limited in its ability to protect your sources and notes. And finally, we'll talk a little bit about defamation law and the way the First Amendment protects defamation law, or protects you as a journalist when you are sued for defamation, that being one of the more common legal actions taken against journalists. Jane, may I turn it over to you?
You may, Kaitlin. Good afternoon, everybody, or good morning, depending upon where you are. And we're really excited to be with you today, and we're only frustrated because we have so little time to talk about such broad topics. We decided we'd start with news gathering risks, broadly speaking. And as the slide said, before you publish, or even if you never publish, you may risk liability based on how or what information was collected. And in this topic, we're actually sort of combining two concepts. One is the First Amendment protection and other kinds of protections, such as it is for the act of gathering news, which could include, for example, whether as a journalist you have a right to go someplace that the general public doesn't have a right to go in the course of trying to cover a story. Then the second thing that we're going to be talking about in this unit is what I would characterize essentially as privacy issues. This is a huge and ever-growing topic, and it's one that we could devote an entire session to. So we're just going to kind of touch on the topic, but do want to bring it to your attention. As Kaitlin said, and as I've said to my students many times, and as I'm sure you've heard from your newsroom counsel, the First Amendment does provide a lot of protection, but as a general rule, journalists are subject to laws of general applicability, which is a fancy way of saying that unless there's a specific law that sets you apart in one way or another, either giving you a special right or imposing a particular duty on you, you are going to be subject to the law that would apply to anybody else. And this, of course, is an outgrowth of the fact that I think really importantly, we don't license journalists in this country. There's a belief that licensing individual journalists would violate the First Amendment, a belief I share. But the downside is that that means that it's often very difficult to define who a journalist is. And even in some circumstances, whether a journalist is doing journalism when they are engaging in activities that might be subject to some kind of legal liability. Trespass and intrusion. I was thinking about this just yesterday when I was reading an article in Pointer about how some reporters at the Los Angeles Times, in the course of pursuing a story about some malfeasance in the police department, were trying to follow up with identified police officers by going to their homes, knocking on their doors. And now the police are saying, you're engaging in stalking, and that's a crime. And of course, the response for a journalist, media lawyer, would typically be, you go to somebody's house, knock on the door, and you leave when you're asked to leave. This is not stalking. But it is important to recognize that physical trespass and intrusion can lead to potential physical liability, as can the use of electronic or other kind of devices for the purposes of gathering news. Now, if you have permission, that's not a problem. But assuming you're doing it surreptitiously or trying to do it without permission could lead to liability depending upon what the laws in your particular state say. Caitlin's slide also mentions wiretap laws. I think we'll talk about this in a little more detail in a second, but just quickly, it's against the law for anybody, unless you're the police or some kind of specially designated individual, to intercept a telephone conversation. But if you are engaged in the conversation, law varies from state to state as to whether you can legally record that conversation or not. Federal law allows one-party consent. Some states have two-party or all-party consent. But for anybody, unless, again, you have a warrant, it's against the law to intercept a communication. And this can extend to electronic communications that are not telephonic communications. We'll talk probably in a minute about the Computer Fraud and Abuse Act and how that can actually be used against journalists and others who engage in hacking. Not a common practice in this country, but if you've been following the lawsuit that Prince Harry has brought in the United Kingdom, you know that unfortunately hacking into phones is something that at least some news organizations in Britain sometimes engage in. Doubtful legality in that country, certainly illegal in this country. Fraud, misrepresentation. This is one of these kind of outlying actions, but it is an example of how a generally applicable law could apply to activities that you might think are perfectly sound news gathering practices. If you misrepresent who you are, if you engage in certain kinds of scraping of data from certain websites, some of that is legal, but some of it is not. And it's very important, I think, to always take a look at the terms of use for any website that you're planning to scrape data from to use for news gathering purposes. A lot depends upon the privacy settings, whether the website has explicitly said that it doesn't allow this kind of data collection. Even then, it might be protected under the law. There are some court rulings that suggest that it would be, but it's always wise to know what you're dealing with and not just assume that, again, because you're a journalist and you are pure of heart, it's okay for you to engage in activities that might be illegal for other people. And the issue of misleading dealings with news sources, Some journalists, for a variety of reasons, think that it's appropriate for them to misrepresent who they are, maybe claiming that that's the only way that they can get a news story by pretending to be, for example, an interracial couple that's trying to rent an apartment or something like that. There are scads of good news stories that have been done that way, but it's worth knowing that there is at least an outside risk that someone might be able to bring an action for fraud or misrepresentation against you. I'm not trying to discourage you from conducting this kind of investigative reporting. I'm just saying that it's important to know what the possible risks are. Next slide, please.
All right.
This is yours, I think.
I will. I'll flag just two things from what Jane raised here. Well, first off, news gathering always prompts a lot of questions. We'd be delighted to hear them throughout this if you can put them in the chat, or we'll reserve some time at the end for questions. So feel free to pop those questions in the chat and we'll answer them in real time if we can. The other point I would flag from what Jane said is there are really two issues that you confront with respect to news gathering. One is we live in a polarized world, and getting more so every day, which is not any surprise to any of you. But in terms of the public's reaction to journalists, the court's reactions to journalists, we are noticing that become more polarized too. And one of the ways we see that come out is with respect to arrests of journalists for news gathering activity, particularly trespassing arrests, curfew violations, all that sort of thing. And it's just an important thing to be aware of. It is always a good idea to represent yourself as a journalist, to be professional, to be clear about who you are and who you represent, and to know the laws with respect to where you are covering, whether that's assembly laws, curfew laws, things like that. The other point I would just flag from what Jane mentioned is she raised privacy, and a point there is all these news gathering issues bump up against incredible changes in our technology, and to be aware that some of the law is a little unsettled with respect to whether it be drones in all sorts of states, something that state laws are trying to control. It's unclear if they even can, but they're trying to. And then with respect to online news gathering, what you can access online, Jane referenced terms of use. Each time you press a little agree, you have actually agreed to a contract. And so it's good to know that this area of the law is a little unsettled, and with respect to it, if you're going to be doing something surreptitious, if you're going to be being a little fancy or cute in your news gathering online, if you're not going to be clear about who you are, it's always a good idea to consult with counsel ahead of time before proceeding with your reporting. Because getting back to where we started, news gathering is an area where even if you decide not to publish, you as a journalist may face some liability. So we'll take a quick deep dive into two other particular areas of news gathering that often get a lot of questions, and again, keep them coming. So recording laws. Now, Jane was exactly right, which is to say there is never a right, unless you're a member of law enforcement, to make a recording with no consent, right? Leave some sort of recording device in a locale and see what you pick up. That is against the law everywhere. But all states and also the federal government have their own recording statutes. These are statutes that interact with the First Amendment, but they are separate statutes. And they do indeed often carry criminal as well as civil penalties with them. So they are to be taken seriously. These days, everyone thinks you have your iPhone, maybe you make your iPhone clear as you're doing your reporting. Shouldn't that cover it? And the answer is, it depends. That's a lawyer's favorite answer. It depends. But so you should know what state you are conducting your recording on. And your journalism in. And often we'll get questions about which state controls. And the usual answer is it's the state who has decided to be more protective is going to be having a greater interest in limiting that recording. So keep that in mind. For example, I am in Pennsylvania. It is, and I know many of you all are as well. Pennsylvania is a two-party state. So that means both parties to a recording need to consent to you recording that, assuming there is some kind of expectation of privacy. And what is that consent? And is it good to get that consent on tape? The answer is yes. It's always, most important thing is to ask, but it's often good to get that on tape as well. And what is an expectation of privacy is something we get asked a lot as well. Again, lawyer's favorite answer, it depends. But if there's a closed door, it's someone's office, you're sitting down for an interview, best is to ask or in some way point to, say, that recording device that you have with you and make it clear that you will be recording the conversation.
Kaitlin, I'm sorry to interrupt you because we were having some technical difficulties along the chat, but there was a question about, what types of information have been accepted in court as proof of consent for recording, right? Which is, it sort of follows what you're saying.
Well, that's a really interesting question, and there have only been so many prosecutions of wiretap that have gotten really high profile, and it's a little different in every state. In fact, up on the screen, it's a little unclear, I don't know if you can see it, is Linda Tripp. Think back to the Monica Lewinsky scandal, if you're old enough to remember, and Bill Clinton. The way all that came out is Linda Tripp, Monica Lewinsky's friend, made a surreptitious recording of Monica Lewinsky explaining her dalliance with the president. She ended up being prosecuted on wiretap charges from the state of Maryland, which is a two-party consent state. So often it's just someone's evidence, someone's first-person evidence, and we get testimony because or sometimes it's the recording itself that provides the evidence. So it's sort of all over the map in terms of what has been accepted. Sometimes there's some video evidence or the like. Usually it is just first person evidence and complaints to police and that sort of thing that proceed through the justice system. And again, this could be either a civil complaint or it also can be a criminal complaint in terms of prosecution. So best practice to ask for consent, and it's great if that recording also reflects the consent. Or if you're in a public street, a public restaurant, there is no expectation of privacy, and therefore, pursuant to the First Amendment, there would be the recording law would not be able to regulate your conduct. Jane, before we move on, anything you'd add in this area?
You're going to mention in a minute, I think, the Bartnicki versus Bopper case, U.S. Supreme Court case that dealt with this issue. And I think it is useful to know that one of the things that is, I think, critical here for journalists is that there's a distinction between you making the surreptitious recording and somebody else making that recording and passing it along to you. In the Bartnicki case, the Supreme Court was basically asked to decide whether that recording, having been made without the consent of the parties involved, because it was a classic wiretap sort of or interception sort of situation, meant that further airing it could create liability for, in this case, a talk show host. And essentially what the court said was that if there was a legitimate matter of public interest, in this case, public health and safety, and significantly, if the journalist had nothing to do with the interception, then the scale would be balanced on the side of protecting that dissemination. But I think it's really important to reiterate what you said, that these laws, as a general rule, are going to apply to anybody, even somebody engaged in journalism. And to simply say, I was doing it in the public interest is not necessarily going to protect you. There is a potential for criminal prosecution, but also for civil liability.
Absolutely. And it just feels very counterintuitive. We live in a world where we think we're always recording, and what's the big deal about making a recording? But this is state law. And this is a law of general applicability, and you need to abide by it. And always best practice is just to seek consent, or make it extraordinarily clear you're recording. And if that person continues to speak, you have some implied consent. But for that very reason that people were asking about in terms of what will work in court, verbal is always best. And while we're on the subject of recording laws, I would be remiss not to flag for anyone who is a broadcast journalist or for a FCC licensed outlet that there are also rules from the FCC about recordings and getting consent for those recordings before a telephone call is aired on a broadcast. That does not necessarily apply to the internet or an internet publication from that FCC licensed outlet, but it does apply to anything that is broadcast. It's an old-fashioned shock jocks law, so just flagging that as well. Moving on to the next slide. Another big issue that we run into as with news gathering for journalists is you all have confidential sources, and the law, for the most part, protects your ability to have confidential sources. But what you need to know is you need to think hard before you extend a promise of confidentiality, because it has consequences for you. So when you agree to provide confidentiality to a source, you are creating a contract with them. Is it on the record? Is it off the record? How are you going to identify someone? So it's really important to be clear what you mean by that. What are the terms of that contract? So it rather than brushing it off, some journalists are like, I'll move on. They agreed to talk to me. No, it's really good to be clear about this and to circle back later if you aren't clear, because when you've granted confidentiality or anonymity in some way, you have created a contract, and according to the U.S. Supreme Court, you can be sued for breach of that contract. Out toward Jane, the Minnesota newspaper once thought it was so newsworthy who was giving the information and providing it confidentiality. There was a leak, and it was during a political campaign, and they thought it was so notable that the newspaper decided to breach their agreement and to publish the information anyway and make it clear who the source was. That went all the way to the Supreme Court, and the Supreme Court held that the newspaper created a contract when they agreed to that confidentiality. And while the newspaper may have had First Amendment rights, here we are just talking about contract. Did you agree? And did you honor the terms of your contract? And if not, you were subject to damages. There's other ways that the confidentiality that you provide to your sources can come end up having legal effect on you. One of the main things is you can receive a subpoena. Now, it used to be that the federal government would send subpoenas to journalists with some regularity, and that has changed under the Biden administration. There's some new guidelines for subpoenas to news media. Now, this is an area where the news media is in, now again, to Jane's point, who is a journalist, but the news media here is the focus for this. And so the federal government will not be sending any subpoenas under these guidelines to any member of the news media seeking the fruits of their news gathering. But no state government has made those promises, and we're still regularly seeing subpoenas come to members of the news media from various state prosecutors and the like, seeking the fruits of news gathering material, whether that is sources, whether that is notes, whether it is outtakes and video. And so keep in mind, when you make this agreement of confidentiality or how you're going to treat the notes, how you're going to identify someone, that can impact then when you get a subpoena compelling you to do something in response to a court order. And if you cannot comply with that subpoena because of the promises you made of confidentiality, there can be legal repercussions for you. You could be held in contempt. You could have, and that can involve jail. It could be fines, and if you are not abiding by that court order. Another way that this can come into play. We're going to talk in a little bit about what it's like to be sued for defamation. If you have, in some jurisdictions, provided a promise of confidentiality, some jurisdictions, Virginia comes to mind, and there's a lot of news gathering that goes on, a lot of cases that are brought in Virginia, you do not get to count that confidential sources material or discuss it. You rely upon it in your defamation case. And so say it was only confidential source information that you relied on, that would be as if you didn't have a source. And so it can have great legal effects on how that case then will proceed. So just flagging that the decision to offer confidentiality has a lot of different repercussions. We're about to talk about some of them, Jane is, in a moment, but to think hard and maybe consult an editor before you do agree to provide that, because both you and your news outlet will be bound by that. Jane, anything you'd add? And I know you want to move on to the next subject, which is ties right into this.
Right. I mean, I guess I would just add as one point of clarification on the Minnesota case that Kaitlin mentioned, Nicole's media case. It's important to know, I think, that this case was kind of an outlier because I think, as probably everybody on this webinar knows, most journalists will take the full sanction that is imposed upon them rather than violate the confidentiality, a promise of confidentiality to a source. What happened in the Cohen case essentially was, I would say, largely a miscommunication between the news organization management and the reporter. Reporters thought they had the authority of the news organizations to make promises of confidentiality. According to the editors, the reporters did not. And so they overrode the reporter's promise, which made the reporters really angry, and then got the news organization into a lot of trouble when the source sued for what amounted to breach of contract. So my takeaway from this is that I think regardless of how you come down on whether confidential sources are good things, bad things, whether they serve the interests of the public or they don't, it's really important to have communication between the working reporter and the management of the news organization to be very clear what the capacity of a reporter is to make these promises and whether the news organization will stand behind the reporter if that reporter should be subpoenaed. These are conversations that shouldn't happen in a moment of crisis. They should happen way in advance, just so that everybody knows from the very beginning what the deal is, what the conditions are. And again, I think this should include a discussion of journalistic ethics. Whose interest is served when you make promises of confidentiality? I think young journalists often seem to come in with the idea that, well, if a source is demanding confidentiality, that means they're really reliable. They have something really important to tell me. That may be true, but it may also be true that you're being used by that source. So I think caveat emptor is the message from this slide and this area of discussion, and to be very careful as a journalist as you make these decisions and make these promises.
And Jane, before we move on to the next slide, we have a really interesting question, which is how can you protect your source when you know that their email is going to be subject to public records laws? So usually a public records law is one of our reporters' best friends, right? Is seeking the communications. But this is a great example of where that might not be the case.
I think this is one of those examples of how newer technology can be a great boon, but it can also open up all kinds of risks. Kaitlin mentioned the Biden administration's revised policy on subpoenaing journalists. And on the one hand, it sounds really enlightened, like the Biden administration understands how important the role of the press is. But there's a more cynical interpretation, and that is that law enforcement doesn't need to subpoena you anymore to get a lot of this information, because they can get it from your internet service provider, they can get it from the telephone company. It varies according to your contract and to some extent by jurisdiction to jurisdiction. But I guess my comment to the specific question here is I don't think the journalist honestly can do much to protect somebody who works for government, whose governments are subject to email disclosure under the state open records law. You can't block the disclosure of that. I mean, in some rare circumstances, I know, for example, constituent emails sometimes can be blocked from disclosure under an open government law, under privacy or something like that. But I would say as a reporter, there would be very little that you could do. So the best advice I can give you is not to use electronic communications that would be subject to disclosure if you're going to communicate with a government employee. I realize that is really frustrating. I realize we like to stay in our offices and use electronic communication, but there's a reason that Woodward and Bernstein met Deep Throat in the garage. If you use face-to-face communications, it's going to be a lot harder for somebody to be able to force disclosure of that.
Absolutely. And you need to abide by the terms of your bargain. For you are not responsible for, there's a lot of boneheaded sources out there. And when they do things that are kind of silly and not thinking, you don't have to protect them to that in all things there. If they are conducting confidential conversations on government email that they should know is not private, then you can only do so much to protect them.
I remember years ago somebody wrote an article in the Society of Professional Journalists magazine, Quill, where they said journalists should have to give Miranda warnings to their sources. And I don't agree with that in a literal sense. Of course, journalists are not the government. But I think you do need to recognize, as Kaitlin suggested, that some sources are more sophisticated than others. Some of them are more aware of the risks than others. Some of them understand more about what your authority to protect them is going to be. And I know that having candid conversation with sources can sometimes mean that the source is going to say, I'm done. I'm not going to continue this discussion with you. It's just too risky. It's up to you, obviously, to try to help them come up with ways to minimize exposure, but ultimately, you can't do everything for them. They've got to be proactive in that regard as well.
Absolutely. Well, tell us a little bit about that, Jane, if we want to move on to the next slide. What's it look like nationally?
Okay, so as the slide points out, every state, with the exception of Wyoming, has recognized some form of reporter's privilege, either through judge-made law or through shield laws or both. But when we say some kind of reporter's privilege, it varies a lot from state to state. Some of the strongest state shield laws, at least in my experience, are in the state of New York, the state of Nevada. They're simple, they're straightforward, and importantly, their courts have interpreted them in ways that I consider to be robust. But the problem with any kind of statutory shield law is the problem with any statute. Ultimately, it only protects what it says it protects. And some of the older shield laws are not very expansive in their interpretation of who is a journalist and who isn't. The best shield law in my mind is one that protects the act of news gathering as opposed to a particular person. But many shield laws speak in terms of affiliation. You have to be working for a news organization as the statute defines it. So the point is to say that you need to know what your state shield law says. Especially in these days when judges don't like to be accused of activism. It's rare for a judge to say, well, you aren't explicitly covered by the statute here, but I'm going to assume that your state legislature intended to cover you. Most of them will go in the opposite direction and become very, very strict constructionalists and interpreters of what the statute says. So you need to know exactly what your statute, who it protects and what it protects. The terminology that you've got on this slide is qualified privilege. And what that means is that you start with the assumption that you have a privilege to protect confidential information, confidential sources, unpublished information, unpublished sources. Again, the exact parameters will be spelled out in the law, but that privilege can be overcome under certain circumstances. It's usually some variation on a three-part test that was derived from the U.S. Supreme Court's decision in Brandsburg versus Hayes back in 1972, which did not, by the way, recognize a First Amendment privilege for journalists who are subpoenaed to testify before a grand jury. But essentially what it said was that you would have to be able to show that the information sought was relevant to the underlying matter, that it was material, meaning essentially that the case would stand or fall on whether you had that information or not. And in my mind, the most important part, which is that it's not obtainable from some other source that would be less violative of First Amendment principles. the big stories, the big cases we hear about often involve circumstances where indeed the journalist is the only source. But in most cases, in my experience, the journalist is not the only source. We are usually the recipient of information from other sources. And so in a state that had a qualified privilege standard like that, often what would happen would be that the court would say, okay, let's say we have information that was leaked from this government department. You, the party that is seeking this, the identity of the source, must go to that department and must depose or ask questions of all the people in the department that could have had that information. It's what's called exhaustion, and it is exhaustive in the sense that you have to basically ask everybody to either say, hands up, I didn't do it, hands up, I did do it, or I'm taking the Fifth Amendment, or whatever it might be. But the point is that a state that has a qualified privilege like that will require the journalist not to be the first place that the lawyer or the cops go to, but basically the last resort. So qualified privilege can be quite protective, and I don't want to suggest that it's not. I think legislatures, for the most part, are very reluctant to enact absolute privileges, so you're far more likely in most states to be dealing with, at best, a qualified privilege. Not that that's a bad thing, it's just that in no way, shape, or form is it going to say that in every circumstance you would be able to successfully resist a subpoena.
And the graphic on the slide is from the Reporters Committee for Freedom in the Press, which we mentioned earlier, the organization that Jane used to lead. And there's a wonderful guide on there with respect to every state's shield law and what it protects. So as Jane mentioned, not only who is covered is worth looking at closely, it's also looking at what is covered, what is protected. So is that confidential sources? Is that unpublished news gathering material? So your notes, your outtakes, and is it even published news gathering material? That one is often not covered, but in the most protective states it is. And the terms of the confidential source protection are also bear looking at. So a wide variety, as you can already tell from the colors on the map. As Jane says, New York is a great place to be a journalist these days for a variety of different reasons. This is also in Pennsylvania one of the brighter spots. There's a good shield law. There's not a lot of good case law in the books and a defamation action for Pennsylvania journalists, but there's a good shield law. Jane, anything else you'd add before we move on to the Bartnicki case you mentioned earlier?
Just one quick thing to say that is kind of a corollary to what we're talking about here. I think most of the time we think in terms of journalists being served with subpoenas. And it's important to remember that once you're served with a subpoena, you have an obligation not to destroy or otherwise get rid of the information that is being sought there, even if ultimately a court rules that that subpoena is not valid for whatever reason. You still could face civil contempt if you have deliberately destroyed material that was subject to the subpoena. Hiding the material is not going to save you. You basically have to act as if the subpoena is valid from the time you get it. The good thing about subpoenas, though, is that there's usually a period of time, weeks, if not months, before you actually have to respond to it in a substantive way, giving your lawyer plenty of time to file a motion to quash it. The distinction, though, that I think is worth remembering is that search warrants don't work like that. We don't hear all that much about search warrants at news organizations, and a large reason for that is because after a Supreme Court decision in the 1970s ruling that the First Amendment did not protect news organizations from search and seizure, Congress passed a federal law called the Privacy Protection Act that gives extensive protection against search warrants being executed on journalists in their newsrooms or their place of work. And there's about 10 or so states that have their own versions of the laws as well. They're quite protective. They cover federal and state officials. And I think the word has actually gotten out. So it's fairly rare for us to hear about search warrants being served on news organizations. But just be aware that that is a possibility. The great thing about the Privacy Protection Act is that it creates a lot of remedies for journalists to fight back. And so I think the word has gotten out to law enforcement that this is not a terribly effective way to try to go after the fruits of news gathering.
So moving on to the next slide, a topic that journals love to discuss, which is leaks. Leaks of information from your sources. And what does that mean for you? This is a bright spot, which is to say that the First Amendment protects your right to publish leaked material as long as you, the journalist, and your news outlet were not involved in any illegal activity. You can know that the material that was supplied to you was provided, was accessed or obtained in violation of the law. You can know that. You just cannot have participated in it. So there's this Supreme Court case, it's Spahr versus Spahr, and like Jane said, it was in the context of union negotiations, actually, and it involved a violation of Pennsylvania's two-party recording statute. So see, it all comes full circle what we talked about today. And a journalist obtained this recording that was, he knew, obtained in violation of the law, but he wasn't involved in that. He just got a tape in the mail. And he aired information about it that was on that. He aired the contents of that, and he was prosecuted. And the U.S. Supreme Court said, nope, you don't get to do that, because he may have known it was illegally obtained, but he was not involved at all in obtaining that information. And so it's a great good news story in terms of your news gathering and the First Amendment's protection. But like all things, there's some of that it depends comes in, and because there are lines and there are gray areas. So you as a journalist cannot coach your source with respect to any news gathering. So this source says, hey, I might have access to something in the bottom drawer of my boss's and the company's files. What do you want? You're allowed to be provided with the material that source obtained from the bottom drawer, but you cannot say, hey, I want this, this, and this is how you get around the company's secure access. That would not be okay. That would be coaching. And the Supreme Court has implicitly said that is not permissible. So it's a natural question. If you've been on news sites, you've seen that there's a lot of places where it says, hey, you got some information, send it our way through this secure Dropbox. And is that okay? And while there's not been a lot of court decisions on it, the answer is we think so, because you're not seeking any specific information. It's nothing as applied, but it's saying, hey, we're available for information if you should choose to provide it. It's not coaching anyone in particular, and it is implicitly by making it confidential. So we could discuss whether there are any promises of confidentiality made with that, but as a general rule, we believe that to be an okay practice. Jane, before we move on to defamation, anything else you'd add?
I would just quickly add that I think, as I'm sure everybody participating in this webinar knows, this is a really controversial topic, and it arises, I think, the Bartnicki case involved, the interception of a phone conversation between two union negotiators. There were no national security issues involved or anything like that. But when we start getting into the area of national security, I think the gloves kind of come off. And so far, thanks to cases like, the Pentagon Papers case and so forth, I think journalists feel pretty confident that they can take classified information or otherwise, confidential information without worrying about having liability for the receipt of that information, putting aside the issue of maintaining confidentiality of the source. But I think it's really important to remind ourselves what Pentagon Papers case didn't say. It did not say that news organizations or individual journalists could never be liable if they had in fact broken the law in the course of either obtaining the information or, in the case of classified information, retaining classified information, because there is a separate provision of the Espionage Act that deals with unlawful retention of classified information. I'm not trying to scare anybody, and most of you are probably thinking you're never going to have to deal with any classified information, but I think, the reality is that post 9/11, especially on the state level, we've had states classifying information in ways that was really unprecedented before the beginning of this century. So I think it's important to just be aware, not that this should dissuade you from doing good journalism, but just recognizing that this is still an unsettled question of law. The Supreme Court hasn't yet had to decide it. They have kind of taken the opportunity not to decide the issue, but the day could come. If Julian Assange ever comes to this country to actually stand trial, we're going to start getting some answers to these questions. So just keep that in the back of your mind, that these are unsettled areas of law.
It sure is. We'll move to our final topic, which is defamation and how the First Amendment protects you as journalists when you are sued for defamation. Little more certainty, although here this is still, it is also an area that is changing. I'm sure you all have been following the headlines with respect to the Dominion case in Delaware. And the sad news is anytime there's a settlement of that many hundreds of millions of dollars, there are plaintiffs' lawyers who get really excited, and we do see an uptick in defamation cases being filed. So Jane, can you tell us a little bit about what defamation is and how the First Amendment interacts with that tort?
Sure. So defamation, is a legal concept that goes back millennia. Pre-biblical times, there was this idea that there ought to be a legal remedy when somebody basically tells lies about you that harm your reputation. So the textbook elements of defamation are publication, which means communication to a third party. Doesn't necessarily mean mass publication, as most of you would be involved in, but simply communicating to a third party. So if you're asking a source about a rumor you've heard about another person, that would technically be publication. It has to be defamatory, which means that it has to be harmful to your reputation. Exactly what that means obviously depends a lot on the circumstances and the individual involved, but it's in the eyes of the so-called right-thinking person. If they would think less of somebody as a result of what was published about them, does it harm them in their business? Does it harm them in their professional capacity? Does it suggest that they've committed a crime or some kind of immoral act or something like that? That's the kind of thing that is defamatory. It has to be a statement of fact, which means that it's provably true or false. Pure opinion is protected by the First Amendment. It's also protected in common law in most jurisdictions. So the question is, can it be proven to be true or false? Materially false is the next element, which means, again, that it's not substantially true. Truth is an old defense to libel. In the United States, it's virtually an absolute defense. So if you can prove truth, you're done. Because under U.S. law, we do not countenance libel actions that are based on truthful statements, however defamatory they might be. It has to be of or concerning the person who is suing, the plaintiff who is suing. Important to know that that doesn't necessarily mean that you have named them. If you have provided enough information that a reasonable person could figure out who you were talking about, that could be evidence that the statement was of and concerning them. It's basically up to the plaintiff to demonstrate that, but it's usually not that hard to demonstrate. There has to be some degree of fault on the part of the publisher. We don't really have strict liability for libel anymore. We did at one time, but it has pretty much been thrown out as a matter of constitutional as well as common law. But remember that fault, at least with a private figure plaintiff in many jurisdictions, can simply be negligence, which is just failure of a duty of care. Exactly what that duty of care is, of course, is always a huge question. It's why at libel trials, sometimes both the defendant and the plaintiff will trot out a professor of media ethics to talk about what journalistic standards are supposed to be. This is obviously very much a matter of, I would say quite honestly, opinion. And ultimately, the finder of fact, the jury is going to have to decide whether there was sufficient fault to underpin a libel action. Not privileged. Most states recognize a number of privileges where certain kinds of statements are not subject to libel law. We'll be talking about them in a little bit more detail, but two of the common ones are the fair comment privilege, which allow you to express a good faith opinion on a matter of public interest or concern, and the fair report privilege, which is based on the idea that journalists should be able to freely report on official actions, government actions, without being held liable for the accuracy of those statements. Government NTSB report has information in it that is false and defamatory. You accurately report it. You attribute it to the NTSB. In most jurisdictions, you would be covered by the fair report privilege. And finally, that it injures the plaintiff. There are certain kinds of libel at common law that were considered to be what's called libel per se. Again, accusing somebody of a crime or somebody of being incompetent in their profession are two examples of that. But in most instances, the plaintiff would have to be able to demonstrate that they suffered some kind of injury. It could be monetary, of course. I run a restaurant, somebody falsely reports that my restaurant is infested with rats. I lose lots of business. I'm able to quantify the amount of money I lost. That's a classic example. But there's other forms of injury too, including emotional distress and other types of sort of intangible claims that plaintiffs can sometimes plead. But they basically have to say there's been some kind of injury to their reputation to be able to go forward.
And Jane, before we move on, and we do need to probably move through this issue pretty quickly, so we have a little bit of time to answer your questions, but we have a question in the chat about what's known as the republication rule. So when you have a libelous quote and you publish it, if you are going to be liable for that. And the question references Pennsylvania, but I'm afraid this is the case in every state, which is to say, yes, there is this republication rule. Jane, could you briefly address that?
Yeah, I mean, I always try to remind my students and journalists that I talk to that republication of a libel, that is, repeating that libelous statement to a third party, is libel, unless it is subject to a privilege, like the fair report privilege that I just mentioned. You can republish a libelous statement that a government official has made. For example, in Minnesota, we had a case a few years ago involving a statement that was made by law enforcement at a press conference. As law enforcement often do, they fingered a suspect as being the perpetrator. Ultimately, that individual was exonerated. He sued the news organization for having repeated what was said at the press conference, and the Minnesota Supreme Court said, because it took place in this context with the government making the statement, it's privileged. That wasn't a given. It had to go to our state Supreme Court to get that established. But the point is, absent a privilege, your repeating of a libelous statement is just as much as a libel as the first iteration of it, and you can be liable for it too. Now, there's some other issues that arise in the online context. How Section 230 of the 230 of the Communications Decency Act provides a certain degree of protection. But as a general rule, I think it's really important to recognize that repeating a libelous statement that's not privileged is just as much of a libel as for the first person that uttered it.
It sure is. Sad but true. If you would like to move through quickly these next couple elements.
I think I did all of the elements.
You may have, yes,
on the list. And so I don't know. I think you're next, or am I next? I'm sorry.
Absolutely. If we could move on, Kathleen, to I had a couple slides. There's one you'll see. One more. There we go. Remember, let's go back one. Trying to keep your timetable here, Debbie. The remembering the fair report privilege is what Jane just talked about. I want to briefly discuss, there's a lot of bad news in the elements of defamation, and we wanted to leave you on a bright note in terms of what do you do when you're sued for defamation, and how do I get out of this? There's a couple big ways to get out early on, and one of those is you can file a motion to dismiss. This is all opinion, things like that. Another thing, as Jane referenced, is this concept of privilege. And the fair report privilege is one of a journalist's best friends. Defamation is a state law claim that interacts with the First Amendment. So there's a First Amendment floor on a variety of these different elements, all of which a plaintiff has to prove to proceed to trial. in a defamation case. So the fair report privilege, all these privileges are also creatures of state law. And the fair report privilege exists in almost every state except Maine, for some reason, does not have a fair report privilege. And the idea is that we want to incentivize journalists to report on government activity, whether that is legislative activity, what the president says, what happened in court today. And so when you are reporting on government information and you report on it accurately, and in many states you are required to attribute to that, you have a privilege to report on that, even if it turns out that information was false. Jane referenced the NTSB. There's a famous case where there was information that was incorrect in a report. So yes, it varies by state. It's another good area to know your state law, but generally it is a really good thing for journalists. Moving on to the next slide, another area comes back to the First Amendment, which is this idea that journalists, that the plaintiff has to prove all the elements that Jane just went through, but probably one of the harder ones is proving fault, proving negligence in the case of a private individual, or in the case of limited purpose public figures and public officials. You need to prove this idea of actual malice. That's that concept that was first developed by the U.S. Supreme Court, or outlined by the U.S. Supreme Court in New York Times versus Sullivan. And it is knowing falsity. It is this idea that prior to pressing publish, you heard a bell ringing of some sort that, oh, I should have checked that. I don't know if that's right. And you said, what the heck? I got a deadline. You publish it anyway. That is actual malice, knowing falsity. And it's been really hard for a lot of people to understand what this is, or if we ever got close to it, until there was recently the Dominion trial. Jane's written about the Dominion versus Fox trial, and it, for a lot of us, was going to be a real test of what is actual malice. A jury was going to have to weigh whether what Fox reported on about Dominion, about the 2020 election, rose to the level of knowing falsity. And it was going to be very interesting to see. As you all know, of course, that did result in a settlement. But so this idea of clear and convincing evidence of actual malice is a First Amendment requirement, and one of the ways the First Amendment interacts with a state law defamation claim, and a very good defense. Unfortunately, you may take something like a deposition, a little discovery to get there, but it is a very good protection for the journalists. And with that, I think we've reached the time we'd ask if you all have questions, so please share them in the chat. And I know Debbie's going to tell us we need to get going.
No, I think you actually, so most of the questions, somehow we had a little glitch, but it has been cured. So this has been wonderful, amazing. And okay, the contact information was in PowerPoint. We will be sending out the PowerPoints. If you have questions afterwards, feel free to send them to us at PMC, and we will distribute them to the right panel. I want to thank you both so very much. This was truly, you covered a lot of information. So thank you. I really appreciate it.
Thanks.
Okay.
Our pleasure.
All right. Thank you.